Hi, Greg Pace with Malek and Malek. So, if you've been following along on the channel, Kip had trial last week. So, a workers' compensation trial, and this was for a claim that was already allowed. And due to COVID and a bunch of other reasons, what year was this injury even from?
Well, this is a 2019 injury.
Yeah, 2019 injury, and then claim was allowed, and then it was a new condition that we went to 2 hearings with the Industrial Commission. It was disallowed, and then our firm filed this into court, and the trial was just last week. So it took like 4 years from the date of the first denial to finally go to court, right?
So here's the thing. So we just, not to go too far in the weeds, but we filed it. I think we dismissed it and we refiled it. But here's the other issue is we've been to the courthouse multiple times, and for one reason or the other, it's been continued. We were ready to go last October. I had everything with me, and we didn't have a jury. So jury is if you want a jury trial, you have to have a jury, and a lot of times, particularly at Franklin County, you're going to have a lot of criminal trials. So criminal trials are going to get first dibs of the jury members, and they didn't have any jury members for our civil case. So it got bounced to Valentine's Day or thereabouts, and then it got bounced again, and so then that's why we're not hearing it till August of 2025.
Right, so this claim was already allowed, which meant he was able to treat for the allowed conditions, get some money for time off work and all that, but he wanted a new condition, and that is the only issue that was there at trial. So this was a disc issue. We're not going to go into too much detail. It was a public trial, but we're not going to talk about the client too much. And what was the result?
Yeah, so there's 2 conditions, by the way.
Oh, 2 conditions.
Yes, do not undersell it. No, it was a unanimous decision by the jury, so that means it's eight jurors, and 8 jurors decided for the claimant both conditions. So he has the right to participate for the 2 conditions that were pursued at court.
And the interesting thing is, despite what you might imagine, is now he has these conditions. That doesn't equal a monetary amount. This just means he can now treat for those conditions. That will have some value to him, but he didn't win money. There's no windfall here, some basic fees, but otherwise now he gets to treat. But we're not going to go into what that means. I don't do trials. I do the hearings and then the management of claims here in the office. And Kip actually went to trial, so I was just going to ask him a little bit how he thought that went. So what do you think was the key to this win? Because you weren't sure how it was going to go. Do you have a...
Yeah, I mean, like I said, Greg, I kind of... As I describe myself, I'm kind of negative Nelly, but it's not so much that I'm negative. I like to approach problems from a standpoint of worst case scenario, and by approaching things from a standpoint of worst case scenario, I can anticipate the problems that are going to arise, and I could kind of plan for that. So I don't think I'm necessarily negative, but I'm kind of realistic, and I anticipate, okay, I'm going to run into this, I'm going to run into that. So with that being said, there were definitely some issues with this case. The claimant, I had no problem with. The claimant's a good guy. That can be a concern, because we could have somebody who, for whatever reason, they either don't testify well, or they have some kind of questionable things in their background. Either they committed crimes or whatever, and so they might not be so credible. That wasn't an issue with this. The problem with this one, the difficulty with this one that I thought was it was a medical issue, and so I was a little bit concerned about that aspect of this particular case. And what I mean by medical issue is, do we have the evidence to prevail in our case? So that was my concern.
Yeah, because most people think, well, okay, I went to the doctor says I have this problem, the doctor says it was caused by the work injury, that should be the end of the story. Problem is, the employer disagreed with our doctor, had their own doctor who saw our client, did a full exam, and this guy's a practicing doctor in some regard, and he came to the opposite conclusion. Do you remember, did he say the conditions don't exist, or just that it wasn't caused by the work injury?
Yeah, and this was a critical part of my case, and so when we do these cases, we're kind of you're given a grab bag of information, and you kind of sift through it, and then you kind of create a narrative or a story. So the issue with this one was, it was this doctor and the IME, and his thing in his IME report. So when at the administrative level, they'll do IME reports, and he was like, this is age-related, degenerative, he had this condition, and this condition was not said to be substantially aggravated by the work injury. And substantial aggravation, I'll get into this in this discussion, but there's substantial aggravation means one thing. I believe at the Industrial Commission, it means something entirely different at trial. And there's that, and then the standard of evidence. But his thing was, this guy had age-related degenerative issues, and it had nothing to do with the fact that he got injured at work, and et cetera, et cetera. So.
Okay, and then you said it was a medical issue, so it was two doctors. I know these doctors because they each do workers' comp all the time. So was this a fact-dependent, or do you think this was jury-dependent? Would you have won this with most juries? Do you think this was a toss-up? Like, what do you think jury-wise?
We got 8 out of 8 jurors, and to be perfectly frank, I think the jury that you get is gonna. That's a big part of the success or failure, because I could have gotten. I'll give an example. I've had another case, and I had 8 jurors that. And I'll tell you how we picked these, but I had 8 jurors, and then one of the jurors that I liked, he was the 8th juror. And so they had another, so what happens is you have 8 jurors and then you have 2 in reserve, backup jurors. So one of the backup jurors got onto that individual's jury. So in that case, it was 7 out of 8. And who was the one person who didn't support it? It was the backup guy who got onto the jury. So in this case, the fact of the matter is, after the case, so just FYI, if you ever get on jury, you're not going to be allowed to talk to the attorney, like in between breaks or after the first day of the jury trial or whatever. While the case is going forth, you absolutely cannot communicate with the attorneys, and the attorneys cannot communicate with you, and if they do, they're in massive amount of trouble. So, but after a jury, we're allowed to go back, after the trial rather, you're allowed to go back and if the judge grants the invitation, chit chat and be like, hey, why did you decide for this or that? So, one of the funny things in this one was this was the second backup. So the likelihood of this individual getting on the jury is fairly low. 2 people would have to, be sick or whatever. But we go in the jury room, and he's not part of the 2 backup people. They're not part of the deliberation, okay? They're separate. They're in the jury pool, whatever. But after the case was done, because I've sat through the entire jury, but after the case is done, we're brought back and they're brought back. And the interesting thing is that individual, he was like, I'm surprised. I would have thought it would have gone completely the opposite way. And I'm like, thank goodness you weren't on the jury trial, buddy. Yeah. Because the reality is, I'm not going to really comment on the individual, but a big part of there's who you have on the jury, but also who's the foreman. And the reality is that individual possibly could have been the foreman. And so his viewpoints might have informed the other jury members. He might have, I don't know, maybe he's really persuasive and he might have persuaded them to his way of thinking. Alternatively, it might have been, 7, 4, and 1 against.
Right.
And then you still win. So, by the way, if there's 8 jurors, I have to have 6 out of 8 for the claimant. So I could lose 2 people and still win. But in this case, it was in a unanimous decision. So. All
right. So with those 8, so there's the big pool, and then it's the Latin word voir dire. How did that go? Did you actually go through it all, or did you just kind of accept the first 8 people?
No. So there's what ends up, they bring a jury pool, and they end up bringing there's 8 people, but they end up bringing 15 to 20 people. And so voir dire, by the way, so if you've never gone to trial, there's different parts. You're going to do, we got to pick our jury, and we do that in what's called voir dire. Whatever it means, all it means to me is we're going to talk to the jury. That's the one time that I can have a conversation with you, the jury members. Otherwise, I can't go during the trial and be like, hey, Joe Bob, what do you think about this? You can't do that. You do opening and closing, and I'm talking to you, but I'm not really having a conversation with you. Now with voir dire, we're having a conversation. What was unique about this one? By the way, we had Judge Spalaza was out for whatever reason, so we had visiting Judge Fry. I thought he did a great job. I thought he was really fair in his decisions, both for myself and for the BWC. But so what ends up happening is we're given a packet of information about each juror. So you fill out, as a jury member, you fill out a questionnaire, and it's about where you work, who you work for, how much money you make, what your spouse makes. It might have, like, have you been involved in a court issue, either, you know, you or somebody you know, either like a civil matter or a criminal matter. And the point, there's other little bits of information, and the idea is we can look at that and be like, okay, maybe I like this person, maybe I don't, maybe this person would be, and it's kind of like picking at tea leaves. There's no real science. Now, if you're doing, you could really get nerd out on this voir dire stuff, but for workers' comp trials, they're really like hearings on steroids. Is essentially what they are. They're just take a hearing that's 10 minutes and expand it into 2 or 3 days. That's what it really comes down to. But so you could look at this list. You have a list of every name of the jury, the seats that they're in, and you get some basic information. And then, so what ends up happening is, in this case, and every judge does things a little bit different. But Judge Fry, I thought he did a great job, but he kind of took my thunder because he asked a lot of the questions that I was going to ask. And so he asked, basically he asked everybody to give a little bit of detail about themselves. And so we learned a little bit more of information. And so what you could do is you could be like, okay, that one I kind of like, that one I'm not sure about, this one I'm concerned about. And then you kind of write these things down. And then you have, he invites invites me, and he's like, hey, Mr. Malek, come on up, ask the jury some questions. So I have prepared questions, and one of the issues that I had, and remember, we're dealing with the facts that we're given, and we got to kind of create, everything that we do as workers' comp attorneys is we're not guaranteeing an outcome. Like, I can't tell you, and anybody who does, run away from them, because that is not an attorney you want to deal with. But we could say, okay, if we do this, we can increase the probability. That's what we do. We increase the probability of a positive or successful outcome. For some claims, legitimately, we can only increase it. It's at the bottom of the floor, and we can only increase it 5 to 10%, and that's just the reality. But other times, we could really push it up. So, and that's the same thing when we're doing a trial. Again, I'm never going to tell anybody, oh, this is the guaranteed outcome, because you're an idiot if you do, and this is not impossible. But what we're doing is we're looking all the information that we have. How can we increase an outcome, a better outcome? So that starts at voir dire. So at voir dire, you would think I'm just asking the jury questions, but I could start going over some of the themes that I'm going to talk about, or some of the issues that I might address in my case in chief. What I might address in the opening, the questions I might ask the witnesses, what I might ask the experts. So one of the critical things in this was, as I said, the issue was this guy, the defense's expert said, hey, this is age-related degenerative, nothing to do with the work injury. One of the things that he said during his testimony, when he was testifying and when he was being recorded, because the doctors, hey, by the way, doctors don't show up at these things. They're videotaped, and then we show their videotapes.
Yeah, and we'll get to that. That's one of my questions. We'll get to that.
But one of the things he said, one of the testimonies is like, well, this individual's 35, and 35 is middle-aged, or something to that effect. And it's like, I don't know where you are, but most people, the reality is most jurors are going to be older than 30, or they could be older than 35. And if you're not that middle aged, and you're kind of like, how old am I? 48. Yeah. I don't even know how old I am. But I'm probably middle aged. I don't necessarily feel middle aged.
Yeah, and for comparison, I'm 36.
I'm middle aged.
This doctor would have said I'm middle aged. And part of the point that Kip's getting to, if I was on that jury, I would have heard this doctor thinks 35 is middle age. That means he thinks I'm middle aged. Am I going to actually then be like, I'm going to go against that doctor? But it's going to make me question the doctor's biases because I'm now imagining, what if this was me? Is this doctor examining me and saying, hey, this horrible thing that happened to you at work, it's probably because you're an old man, 36-year-old. And that's not what the jury was told, but that might be partially what the jury heard. So you can go back.
Yeah, and that's the point. It's like most people would consider 35 is probably not middle-aged. And so that kind of draws into question anything else this doctor says. And so one of the questions I asked the jury, I was like, you know, do you folks think 30 to 40 is middle-aged? How about 40 to 50? Raise your hands. How about 50 to 60? Raise your hands. If we had to put a number at what middle-aged is, what would number you'd put? 50. So now the jury's agreeing that 50 is middle-aged, and then they're going to hear that this guy, and they don't know that this guy is going to testify that he's 35, and then they hear, oh, this guy's going to testify that 35 is middle-aged. So I've already won, not that I've won anything, but I already kind of, like Greg is saying, brought into question.
Yeah, so you were building your argument before they realized you'd even started arguing.
Yeah,
right.
Yeah.
Okay.
And here's the thing: you can't really be so on the nose. You got to be a little bit nuanced about this, because the judge might jump in and be like, hey, don't argue your case during voir dire. So you gotta. It's a fine line, but I thought that was. I thought if I want to pat myself on the shoulder, I will on that point. But so here's the thing. So I asked some other questions. And these other questions, Greg, was, again, to sift through who I want and who I don't want. And so some of the questions I was able to ask, and I was like, okay, this person answered this, and this, so I probably don't want this, and this person on the jury. So then I'm done. They go up, ask their question. Defense asks their question. And then the jury's removed out of the room, and then we do what's called, we challenge. And so there's challenge for cause and there's peremptory challenge. So we each side, plaintiff and defendant side, we get 3 peremptory challenges. So meaning we could knock off 3 people. And it doesn't, FYI, doesn't mean we don't like you. It just, don't take it personally. It's just, we're just, you know, if you don't get chosen, it's because you, for whatever reason. But so, you know, we go through this, and the reality is, what's interesting is the defense in this case got rid of some people that I wanted to get rid of.
Yeah.
But they thought that they wanted to. So I was like, okay, I like that.
Yeah, that's the fun part of it is you're playing with different variables, they're playing with different variables, and you might come to the same conclusion. You're using the same pool, so.
Kind of like blackjack or
really,
or something.
Yeah, where you're not even sure what your cards mean, but you're making bets off of them.
Yeah.
All right, so just real quick, 'cause we're getting deep into this. So this was a 2-day trial, right? So what was the timeline? Because you imagine like on TV where it's hour after hour after hour of testifying. So what was the timeline?
Yeah, we kind of ripped through things, that's what I appreciate Judge Fry. But so we do voir dire, we pick the jury members, and then there's no cause challenges, but we pick the jury, our jury's seated, and then we start on opening. So we do opening, plaintiff, defense, and then we move on to late witnesses. So we only had one witness, the plaintiff. Okay. So I do direct, cross, redirect.
Okay.
And then that's done. So the late witness part of it. Now we're in the plaintiff's case in chief. The next thing is our medical expert, and then we torture the jury with an hour and a half of pure tedium. But it is what it is. So meaning you have to watch this video. This me asking the doctor questions that are related to.
Yeah, and this surprised me when I learned this is how it works. So you said the doctor wasn't there. This was a interview that you did, the deposition, months in advance.
And in fact, this had taken place in October, November of 2023.
Okay. So you go to lunch at some point, you're talking to our client, and then it's just playing a video for, well, how long was the video?
It was about an hour and a half, and
okay.
I think we had gone through, because I think we did sat in the jury, and then we did opening and direct, and then we finished up till, like I was done with my direct, and then we cut it off for the day. So that was like 4 p.m.
Okay. So then that's day 1, and then day 2.
Day 2, it's their cross on my expert.
Okay.
And that was like an additional 30 or so minutes. And then usually at that point we enter in exhibits.
Yeah.
And then the employer makes defense. They say, we're arguing that for a directed verdict, and 99% of the time, these types of cases, the judge is like, no, there's evidence rejecting your motion. And then we enter our exhibits, and then they played their doctor's depo.
Yeah.
And again, we tortured the jury for an hour and a half. And then we do closing.
Okay.
Yeah.
And then, so it's...
And then they deliberate.
Yeah, early afternoon, and then how long they deliberate?
They deliberate in this case, I want to say, for 2 hours, and it was 2 long hours for me. What ended up happening is the judge wanted them to have access to the depots. So what I did is I got the employer's doctor's depot, or the defense's depot, and my depot, expert's depot, because they couldn't. I guess the state can't give up their laptop because it's got state secrets.
Yeah.
So I did it, which is fine. So I gave him my laptop, and then I was like dying.
All right,
out in the hallway.
So 6-year-old claim, 2 years of prep and waiting, multiple delays. Day and a half trial, 2 hours deliberation. You got your answer?
Yeah. So, and then they deliberated, and obviously the unanimous decision. So, I mean, to be honest with you, I was surprised, but I'm kind of, like I said, man, I'm negative Nelly. So I'm always going to be like, we're going to lose.
Right. So obviously you already knew all this stuff, so there's a different level of interest and tedium, but did you get a feel, and I'm just curious here, the hour and a half deposition on a video, break, hour and a half deposition video, spread out over 2 days. Was the jury bored? Like, are they interested in this?
You know what? To be honest with you, I mean, the funny thing is, after we went, like I said, we went back to the jury and we were talking with them, and the one lady said, I was really hopeful that I would get on the jury. So I think although it was boring, it wasn't. The thing is, it's a 2-day trial and then you're done, and like you've gone through it. Versus like some of these criminal cases and PI cases, it could be weeks and weeks and weeks. So it's like they've done their thing, and I think they're off the hook. Yeah. So it's actually not a bad case if you get called. It's not a bad case to get called in. Yeah.
I guess I'm just wondering with the nature of it, and you said it. You seem like it's maybe jury dependent, or maybe it's expert dependent. Of just, would the jury be more swayed by opposing doctor there in person versus just sitting there? And by the end of the defense doctor, they're in hour 3 of watching these doctors talk. I just wonder if they're even paying attention at that point.
I think their minds are wandering, but I think you get a new face, you're gonna listen to it. I think the recommendation for both plaintiff or defense is get in and get out. Like, I mean, to be honest with you, mine was too long. But the problem is 2 conditions, and that's kind of had to be. But you almost want it to be like 30 minutes, 40 minutes, and then, because like you're right, it's like it's whatever, man. You're killing me with this tedium, you know.
Yeah.
But as to your question, I think if a doctor was there in person, I think it might have more of an impact for sure. Is that going to happen? Probably not, because it's one that'd be real expensive too. These things are continued all the time. I mean, the doctor, I don't know, man, that would stress me out trying to coordinate that.
Yeah, that's just another thing to keep in mind. If you're wanting these to go to trial, you're wanting to pursue it, which is definitely your right in that situation. This trial was scheduled, twice and got continued, and actually was scheduled?
I don't know, 3 or 4 times.
3 or 4 times.
Actually.
This trial, this time, was actually scheduled for Monday, but a criminal trial was scheduled, and it actually started on Tuesday. So if our doctor had to be sitting in the wings, that's just an extra day. And then the next time that we need to use this doctor and we say, hey doctor, are you going to testify? Are they going to say yes if we're asking them to be there in person? I don't know.
Probably not. And I'd say about 99% of all these doctors are done via the video. So, and that's fine. We could do that. And I don't think, to be honest with you, I think that's okay. I think most people are fine with that. Is there a boost for the doctor to be there in person? Yeah, there would be a boost.
But what's clear is the defense knows that as well, and their doctor wasn't there. So this is just how it goes. So For our guy, we weren't sure how this was going to go. We weren't sure what this would do for him, but he wanted to stick it out, and now he gets to
he gets
the right to participate. So obviously we're happy for him. So and then you got the win. So
yeah, but here's the thing. I mean, FYI, like I plan when even though I'm negative Nelly, don't construe that as meaning I don't prepare for these like to the 10th degree. Everything. I consider everything. Like I had motions that I had filed, I had potential cross, and this is all. A lot of this stuff is like a chess game, and you know what moves are going to be made. So it's when you guys go to trial, it's not like TV where it's like surprise. It's we know what they're going to say. They know what we're going to say. They generally know where we're going to go. At that point, it's just presenting it to you. But to your point, do you think? I think jury makes a difference. I'm not sure. I think in Columbus, and I think in general, I think most juror members are sympathetic to injured workers because I think most people they kind of superimpose themselves on the injured worker, and they're like, if this was me, I'd want this to be allowed.
Yeah.
And I think so here's the reality. At the Industrial Commission, that dynamic is flipped.
Yeah.
And you have a hearing officer who's heard thousands of hearings, and they've heard every permutation of argument, and there's a level of cynicism and skepticism that's just inured through that doing a ton of these things. Yeah. Whereas when we go to jury, we go to trial, it's like these people, they might not even ever had a workers' comp claim. And surprisingly, in this one, I was surprised. I think maybe one person may have had a claim. There were maybe one or two people, but most people are like, I don't know what that is.
Right. Yeah. Right. Yeah, and my hope is, and I'm biased on this side, but that they see themselves in that position, and they're filing a claim, and they don't want their employer to fight this. They don't want the BDC to fight this, and they just think, well, this was me. If this was my brother, if this was my daughter, I would want the claim to be allowed. I would want this condition to be allowed. You should get to treat for this only because some random doctor said otherwise. I don't want this denied. And maybe that's what it was. We don't know.
Yeah, they had, just speaking with them, they're a little, they're essentially saying essentially the same things. They're sympathetic to the injured worker, but yeah. But yeah, I mean, I do think you're going to have a better result at trial. But here's the deal, guys. You have to understand, like, this individual had to be on call multiple, because remember, we were ready to go to trial last October. So this individual had to take off the week, because I don't know if it's going to start Monday, Tuesday, or Wednesday. Mm-hmm. And he had to take off the entire week. I had to take off the entire week. And I do this for a job, so who cares about my time? But his time, this guy, in fact, worked or whatever, and he had to take off time for his case. That was one consideration. And it's just a lot of work, man. And so the reality is, you're like, well, I want to go to trial. Well, the reality is, one, you could lose, Yeah. And there's one thing you could lose. But not every case is a great case, to be honest with you. I have a triumvirate, like a triangle, and I need a medical expert. Mm-hmm. We don't always have medical experts, unfortunately. Just because you treated with this surgeon or that surgeon or this doctor, that doctor, we'll reach out to them and be like, no, I absolutely don't want to testify. So that's the first challenge. The second challenge is the mechanism of injury. Is it a compelling mechanism of injury? Does it make sense? Because if it's ridiculous, I don't care if you're the world's greatest attorney, you're probably still going to lose because it doesn't make any sense. I can't sell something that doesn't make sense. So you need a good injury, you need a medical expert, and then again, you need a claimant. If there's some weird thing about the claimant, and here's the reality, in this one, there was a weird aspect of it. There was an issue of let's just say, there was one of the issues that could have come up with this one was the element of racism. And you might say, and I'm not going to really go into why that would have come up, but that could have definitely come up with this one. And I had to do some motion practice to make sure some things didn't come in. And then the other issue is, you're like, well, could you have done for cause challenge and voir dire? You can, but people are going to hide their things. Like, I'm not going to say, hey, Greg, Do you hate white people?
Yeah.
I hate white people. I'm part of the anti-white people league.
And not just that, you don't want the other jurors you're not accusing it of to think that's what your angle is.
Yeah.
That you're the white savior attorney who's going to accuse everybody on the jury of being racist.
Or I don't want it to be about, like,
Yeah.
Greg is from
Right.
England, and I don't want the case to be about Greg being from England.
Right.
And so that's the issue. So there's always going to be the reality is every workers' comp claim, whether it's at the administrative level or at the trial level, there's always going to be perfect injury and a twist.
Yeah.
You know what I mean? It's
That's
like
definitely true.
it's like this, but the person was smoking crack or something. You know what I mean?
Right.
And it's always some weird thing. and that was the weird thing in this one.
Right.
You know. So
All right. Well, I think we're about 30 minutes in, so that was all my questions. Glad you won.
all right, man. why are you glad? He was out here drinking pina coladas.
Yeah.
And no.
I'm answering the phones while he was out there.
It's true. The
trials.
reality is going to trials is like slightly being on vacation, although it's kind of being on vacation.
Yeah, not quite.
Yeah, not quite. Anyways,
All right.
thanks for listening, folks.
Thank you.
Bye.